chat room. Egregious.
Okay, good evening, everyone. This is the April 23rd, 2020 meeting of the Santa Monica Rent Control Board. Thank you to everyone who is joining us. We're still adjusting to this. Bear with us for the technical issues. Okay, in an effort to reduce the spread of COVID-19, we are meeting via video conference. The meeting will be broadcast on City TV, Channel 16, and streaming on the city's website as normal, but participants may join via the methods posted on the Santa Monica Rent Control Board website. People who wish to make public comment may request to give public comment via email by emailing rentcontrol@smgov.net. As we continue to adjust to COVID-19 impacts, we'll be implementing the same protocols. Can we have a roll call, please?
Commissioner Foster.
Here.
Commissioner Torosis.
Here.
Commissioner Duran.
Here.
Commissioner Sultan.
Here.
And Commissioner Phyllis.
Here.
All present.
Next item on the agenda is approval of the minutes from April 9, 2020. Is there a motion to approve the minutes?
I reviewed the minutes and I move to approve the minutes from the last meeting. Second.
We have a motion by Commissioner Foster and a second by Commissioner Torosis to approve the minutes. Can we have a roll call vote?
Commissioner Sultan.
Yes.
Commissioner Torosis.
Yes.
Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
And Commissioner Phyllis.
Yes.
Motion carries.
The next item on the agenda is special agenda items and announcements pertaining to the Rent Control Board. We'll be hearing from Ms. Condon, our Executive Director. Do you have any announcements for us?
Yes, I do this evening. Good evening, commissioners and members of the public. I have a few announcements this evening. I wanted to let everybody know that the spring issue of the Rent Control News should be in property owners and tenants' mailboxes by the end of next week. That newsletter has a lot of important information about the current situation, the current emergency situation, information about the eviction moratorium, frequently asked questions, a variety of resources available to the public, as well as the exact language that owners need to use to notify tenants of the eviction moratorium. They're supposed to start doing that as of tomorrow. And as I said, that language will be in the newsletter that we send out. Also, the newsletter will be announcing a survey that we will be conducting to find out how widespread the issue is of tenants' inability to pay rent as a result of the COVID-19 emergency. We've been learning anecdotally that certainly tenants are impacted, but we'd like to get as much information as possible, both from property owners and from tenants, so that we can begin to understand how widespread that is. So we encourage everybody to please go to our website to complete that survey once they have that information from us, and the survey should be available by the middle or end of next week. We will also send an email blast out to all of the people whose email addresses we have in advance of that. And finally, I took a few minutes in our last meeting to talk about how the agency had pivoted to be able to provide our services by teleworking and holding teleconferences and video conferences. Tonight I just wanted to mention a few of the things that our staff has been doing to assist the city in the response to the emergency. We've had a number of our staff members take shifts on the city's hotline that was established to answer questions from the public about the emergency orders that have been issued and just to ask general questions. We also have had employees calling senior citizens throughout the community to check on their well-being and to see if they're able to get groceries and medicine and to connect them with services if necessary, and also to inquire of them whether they're having difficulty paying their rent. They did that, our staff members did that along with a team of people that were led by the Community and Cultural Services Department. Having completed that project, the same group of people are now calling families throughout the community to see how they're doing. So I'm very proud of our staff being able to contribute some time to help with the city's emergency response. And I wanted the board and the community to be aware that we've been assisting with that. And that's what I have for announcements this evening.
Can I ask a question?
Sure.
So the hotline that can be called by anyone in the city, are they assisting with landlord-tenant questions?
They are answering them and then referring them both to the rent control agency and to the city attorney's office or to the appropriate department. If it's code enforcement, they would refer them to code. But we are getting a lot of referrals from the hotline, as is the city attorney's office.
Okay, at our next meeting, I'd love to know the breakdown of the calls that are coming in to that line versus our line.
Yeah, I've asked for that. I have not been able to obtain that information, but I will keep trying.
Great, thank you.
Great. Okay, our next item on the agenda is item 10A. Oh, sorry, is public comment. Item 7, and it appears that we do not have any speakers for public comment. So we will proceed to item 10A, which is our jurisdictional item, an exemption for new construction pursuant to Charter Section 1801C5 for 1423 Franklin Street. May we have a staff report, please?
Wait.
Yeah, I'd like to make a motion. Chair.
Yeah.
This case is very straightforward. The law is very clear. When we have new construction that's not replacing Ellis units or removal permit units, the owner has met all the requirements, and the recommendation is to grant. I move that we grant.
I second.
Great. So there was a motion and a motion by Commissioner Foster, a second by Commissioner Torosis. Can we have a voice vote, please? Or sorry, roll call vote. Nope.
Commissioner Salton,
Yes.
Commissioner Duran,
Yes.
Commissioner Torosis,
Yes.
Commissioner Foster,
Yes.
and Commissioner Phyllis.
Yes.
Motion carries.
Great. Next item on the agenda is item 10B1, which is an appeal relating to 1321 Harvard Street, unit number 6. The landlord appeals the hearing officer's decision denying the landlord's petition to find tenants not in occupancy of their unit under Regulation 3304. We do have speakers on this item. Is there a staff report?
There is, Commissioners, whenever you're ready.
May we have the staff report, please?
Commissioners, the petitioner in this case and the appellant is Diane Chekaloff, who is the owner. The James Harmon Ms. Harper and Mr. Shundoff are the tenants who moved into this unit. Ms. Harper moved in back in 1994, and then her husband joined her in 2005. The unit has 2 bedrooms, and when Mr. Shundoff was furloughed in March of last year, their close friend, Ellie Kransky, and Mr. Kransky's husband, Matthew Coleman, moved into the other bedroom as their roommates to help share the rent. Ms. Harper and Mr. Shundoff also bought a home in Oregon in 2018 after they sold their previous vacation home in Big Bear. After Mr. Shundoff was furloughed, his employer asked him to return to work on a per-assignment basis to help wind down the company's operations. There are periods in which he waits for an assignment, but when he gets it, Mr. Shundoff says that he must be physically present in Santa Monica. But when he's not required to be here, Mr. Shundoff has spent time in their home in Oregon. Ms. Harper works for a veterinarian hospital and lab network in West LA. She can work remotely up to 10 days and sometimes does so by staying in Oregon. Ms. Chekaloff, the owner, believed that the couple no longer primarily reside in Unit 6, so she petitioned the board to find them as tenants not in occupancy and to reset their rents based on market rents. Mr. Shundoff testified at the hearing for this case that after he was furloughed, he spent half of April, most of May, 3 weeks of June, and 3 weeks of July in Santa Monica. He was away in August, and he spent 1 week of September and most of October in Santa Monica. Ms. Harper testified that she spent half of the period between June to August in Santa Monica. Their roommate, Mr. Kransky, testified that Ms. Harper is there about 2 to 3 weeks a month, and that there has never been a month when both Ms. Harper and Mr. Shundoff were absent from the apartment. Mr. Kransky's husband, Mr. Coleman, corroborated that testimony. Ms. Harper and Mr. Shundoff submitted driver licenses, pay stubs, tax returns, and other financial statements to show that Santa Monica was their domicile. They testified that their primary care physicians were at UCLA, their bank was in Santa Monica, and they had an active gym membership in Santa Monica. To refute their testimony, the Chekaloffs preferred a few stills from their security camera to show the absence of the tenants in the property. They could not provide the surveillance footage because they said that it had been recorded over. The few stills that they did submit provided a limited snapshot of scattered moments over 90 days. One was of a party in the yard, supposedly a birthday party for Mr. Kransky. Another of a woman that no one could identify. Another of Ms. Harper's mother, who also lives in the complex, walking Ms. Harper's dog. The hearing officer found this evidence to be of little probative value. The Chekaloffs also submitted images from Ms. Harper's Instagram page that showed the couple was on vacation. They also submitted internet searches that showed that the Oregon property was in Portland, something the tenants hadn't disputed, but the Chekaloffs argued that the Oregon home couldn't be a vacation home because it was an urban setting. The Chekaloffs also submitted declarations from 2 tenants in an adjacent apartment building, who wrote they did not see Ms. Harper or Mr. Shundoff as often as before, but the Chekaloffs never subpoenaed those tenants to the hearing where they could testify and be subject to cross-examination. And those tenants declined to appear. And because their declarations were hearsay, the hearing officer gave them less weight as evidence. The Chekaloffs also focused on the apparent absence of Mr. Shundoff's cars. He testified that he had moved his Porsche to the Oregon property to keep in a garage there, and that he kept his Toyota at work, although he had been using it to bring his items to Oregon. Mr. Shundoff, however, also testified that he works really close to home and he uses his bike usually to get around in Santa Monica. The Chekaloffs said that Ms. Harper's car was absent from the carport where she usually parks it for most of what May, and notified her of their petition. Ms. Harper, however, submitted repair invoices that showed her car was in the repair shop for most of May. The Chekaloffs also pointed out that the subtenants, Mr. Kransky and Mr. Coleman, testified that they paid 60% of the rent, suggesting that they do this because of how infrequently Mr. Shundoff and Ms. Harper actually stay in the Santa Monica apartment. The subtenants explained, though, that they do this because the utilities are in Mr. Shundoff and Ms. Harper's name, and they pay all the utilities, and it's easier to just do a 60-40 split instead of splitting the utility bills on a monthly basis. The Chekaloffs allege that the hearing officer was biased in her decision because she failed to consider the evidence they presented. Merely ruling against their claim, however, is not evidence of bias under the law. The hearing officer admitted and considered all the evidence that they preferred, even some of doubtfully relevant value. The only exception seems to have been evidence that they wanted to submit about the profitability of the rental business, but the hearing officer was right to deny admission of that evidence, as it is entirely irrelevant to whether Ms. Harper and Mr. Shundoff continue to be domiciled in their Santa Monica apartment. Board members, you know that you review this matter as an appellate body, and so you may overturn the hearing officer if it would have been unreasonable for the hearing officer to reach her decision in this given the records that was before her. But because there's more than a preponderance of the evidence that show that Ms. Harper and Mr. Shundoff continue to reside in the Santa Monica apartment as their principal residence, staff recommends that the board affirm the hearing officer's decision and findings of fact and conclusions of law.
Thank you. So this evening, we have a bountiful speakers list. For this item, we have, for our speakers and for the benefit of the public, because we're doing this on the internet, we have speakers Kevin Chekaloff and Kaylee Chekaloff, who are the appellants. And then we also have Ms. Harper and Mr. Shundoff, who are the tenants. Because this is an appeal, each side will have 10 minutes maximum per side. And the appellants, each individual, or the primary appellant, will have 5 minutes to speak, and then they can allocate the remaining time as they see fit among the speakers for their side. We will help everyone along the way to make sure that they understand the speaking time limitations, and I will start by calling Mr. Chekaloff, followed by Ms. Chekaloff, and Ms. Harper and Mr. Shundoff will be waiting in the wings. When we do these invitations to speak or elevations for attendees, it takes about 30 seconds to connect, so just bear with us while we are connecting. Mr. Chekaloff, I am inviting you to provide your public comment now.
It looks like he dropped off for some reason.
I invited him. Oh, did he get elevated? Let's see.
Oh, no,
Yeah, he's been elevated. Okay. So Mr. Chekaloff, I'm going to unmute you, and you will have 5 minutes. Mr. Chekaloff, are you there? If you are speaking, Mr. Chekaloff, we cannot hear you, but you can chat with us if you have questions using the chat functionality. And if we have additional technical difficulties, we can skip you for now in the queue and go to Ms. Chekaloff. But we are waiting to hear from you on chat if you're having technical difficulties. Okay.
I'll give him a call.
Okay. So, Mr. Chekaloff, our board secretary is going to give you a call. I, for now, am going to, Mr. Gwynn, do you think it would be helpful to remove Mr. Chekaloff from the queue, or should we leave him in there, in the presenter queue?
We probably should demote him just so that I can talk to him without him all of a sudden coming on.
Okay, no problem. Having some difficulty myself with this. Mr. Gwynn, are you able to demote him? It's not giving me that option. Clicking on the,
yeah.
oh, I got it,
Oh,
sorry.
I got it.
Okay, thank you. Okay, so our next speaker is Ms. Kaylee Chekalov. It looks like from the check-ins on our attendees, it does not look like Ms. Chekalov has signed in. She may be trying to participate through her husband's queue. Let's see, Lonnie, if we can get this worked out. Because I think it's obviously important that they have the opportunity to be heard. Mr. Gwynn and Mr. Lewis, would you recommend proceeding to hear public comment from Ms. Harper and Mr. Shundoff at this time? Or should we hold for a little bit longer?
There are a couple of things that the board could do. One is that it could skip to the next appeal if the parties for that are ready. The other is it could hear from the respondents, so I believe with the tenants in this case first. But because they're only responding to an appeal, it probably makes more sense to wait to see if the Chekalovs come on. So if the other party,
and I do see them in the queue, so they are here. They clearly want to participate. I think they just must be having technical difficulties.
there's no legal reason why the board cannot hear from the tenants first.
Okay. Is there consensus among the board? Should we hear from the tenants first, or should we table this item and go to the next? I do see that the one speaker on our next item is ready and available.
I would go to the next item and come back to this item because I think the appellants have the right to speak first.
No objection to that?
No.
That seems fair to me. Okay, so we are temporarily tabling this item so that Mr. Chekalov can hopefully remedy some of the technical difficulties it looks like we're having. Our next item is item 10B2 D5170. May we have a staff report, please?
Commissioner, the petitioner and the appellant in this case is tenant Nicole Rostaker, who lives in Unit 6 at 300 Bay Street. Ms. Rostaker filed a rent decrease petition alleging various maintenance conditions. The hearing officer granted a decrease for some of them. She has appealed 4 items for which she did not receive a decrease: mold from a May 2019 leak, malfunctioning blinds, a noisy pool pump, and accumulation of recycling and debris. As petitioner, Ms. Rostaker bears the burden of proving that the condition of which she complained exist and that they are a significant reduction in housing services. Her principal outstanding complaint appears to be mold. The record is clear that work in the upstairs unit caused water to leak through the ceiling into her unit back in May. But the contractor working in the unit testified that he responded within minutes of receiving her call. He found the source of the leak, stopped it, opened up the flooring, and set up a dehumidifier to dry out the area. The hearing investigator visited the property prior to the hearing and observed a small gap between the ceiling and the walls in her living room. She testified, however, that the ceiling was dry during her visit. After the hearing investigator had visited, the contractor caulked and sealed that gap, and that was confirmed by Ms. Rostaker. Ms. Rostaker believes that mold is still present in the walls because the repairs failed to properly remediate the problem. But the record shows little evidence to corroborate her belief. She complained first of nasal congestion, but she didn't offer any evidence that had been caused by the alleged presence of an elevated level of ambient mold. She submitted a mold report from June of 2019, a month after the leak, but she failed to produce a witness from the testing company who could explain the test results, testify about whether there was the presence of mold in Ms. Rostaker's apartment was any higher than normal, and to be subject to cross-examination by the other side. Because the report was hearsay, and in any event included no explanation of what its results mean, the hearing officer gave it little weight. Ms. Rostaker did not provide any other evidence that proved the alleged presence of harmfully elevated levels of ambient mold. She also alleged that the blinds in her bedroom are damaged. When the hearing investigator visited her unit, she only observed minor scuffs and marks along its edges. She has had the same blinds, Ms. Rostaker, since she moved into her unit 22 years ago. Ms. Rostaker testified that the manager, Ms. Hagan, had the blinds cleaned and rehung, but that they do not open or close correctly. She did not submit any evidence at the hearing to corroborate her claim. Ms. Hagan, however, testified that she tested the blinds herself weeks prior to the hearing and they functioned properly. She also submitted a video in which she is opening and closing the blinds with ease. Given that record, the hearing officer reasonably found that the evidence failed to prove the blinds malfunction. In her appeal, Ms. Rostaker sought to provide new evidence in the form of a video that she alleges show that the blinds do not turn correctly. But this is an appeal, not a do-over, and Ms. Rostaker could have produced that evidence at the hearing, but she failed to do so. And because the video is not in the record, the board shouldn't consider it. Ms. Rostaker also alleged that the pool pumps malfunction and are very noisy. The alleged complaint, however, was not listed in her petition. Therefore, the hearing officer found that to consider it would have been a violation of due process. Due process requires a minimum notice that a claim liability will be under consideration by a government entity and that a hearing will be held by the government on that claim. Since Ms. Rostaker failed to raise the issue in her petition, the owner had no notice that liability for the alleged condition would be considered at the hearing, and considering it on appeal would be a violation of the owner's constitutional right to due process. But Ms. Rostaker alleges in her appeal that she did raise it in her petition, and she provides a copy of the relevant page, which lists the pool problem. But that's not the copy of the petition that she filed with the board. The staff report includes a side-by-side contrast of the page actually filed and the one Ms. Rostaker may have wanted to file. The hearing officer's decision to not consider this alleged condition, therefore, is supported by both the record and the law. Finally, Ms. Rostaker complained about the accumulation of garbage and recycling in her petition. When the hearing investigator visited the property, she observed some construction-related waste and cardboard, but only inside the carport. The manager testified that she ensures that the recycling area is cleaned on a weekly basis. The hearing officer found the photos show only a minor problem that does not warrant a rent decrease. In her appeal, Ms. Rostaker complains that recently the management has failed to designate a staff person to take barrels out to the curb, and the responsibility has fallen on the tenants, which has led her to file a complaint with code enforcement. The alleged new conditions, however, were not the subject of her petition and occurred after the record was closed in this matter. Should the conditions persist, Ms. Rostaker may file a new petition for rent decrease in accordance with the board's regulations. Again, this is an appeal, so the board reviews this matter as an appellate body, and it should only reverse the hearing officer on any condition, only if the evidence shows the hearing officer's finding to have been entirely unreasonable. Given the absence of evidence to prove a significant problem with mold, malfunctioning blinds, and accumulation of recycling, and Ms. Rostaker's failure to list the pool pumps as a problem in the copy of the petition that she filed, the hearing officer's decision is reasonably supported by the record and the law, and staff recommends the board affirm the hearing officer.
Great. Okay. We have one speaker on this item. It is Miss Nicole Rostaker, and I've seen Miss Rostaker's name in the queue. Ms. Rostaker, I'm going to elevate you so that you have the opportunity to participate. You have 5 minutes as the appellant. There will be about a 30-second delay, and then I will unmute you so you can start your time. Welcome, Ms. Rostaker. Are you able to hear us? Ms. Rostaker, it looks like you, hi, Ms. Rostaker. I can see that it looks like you're lighting up, but we are unable to hear you. Do you want to try again?
Yeah, good evening. I'm trying to see.
Good job. We can hear you now.
You can hear me?
Yes.
Okay, good evening, everyone. Thank you for letting me test my case. So 5 minutes, is that right?
Yes.
Okay, so regarding the item A, which was insufficient evidence of mold, with all due respect to the hearing officer, I just wanted to state that I strongly disagree with the hearing officer's statement in the letter to the tenant for the notice of appeal stating that, quote, but the contractor working in the upstairs unit testified that he responded within minutes of receiving my call about the leak. He found the source of the leak, stopped it, opened the flooring, and set up a dehumidifier to dry out the area. The actual response timeline from the contractor was not until the 22nd of May, 2019, and his projected plan, which did not immediate opening of humidifiers were not
Ms. Rostaker, you've broken up a little bit. We're unable to hear you. We're cutting in and out.
office.
Ms. Rostaker? Okay.
I somehow got lost there. Are you able to hear me
Yep.
again?
Yep, now we can
Okay.
hear you.
So on the 23rd of May, Officer Efrain Galindo of Code Enforcement arrived to my unit by my own personal request, as I had called him the evening of the discovery on the 20th of May, after also speaking with the contractor to update them that I had found the leak from unit number 12's brand appliances that were installed and that leaked into my living room. I rehired VM3 Environmental to evaluate the water damage in the living room ceiling on the 28th of May, and that person from VM3 Environmental found that the ceiling was still actively wet. Despite the contractor, Roberto Alonso, claiming he had dried out everything from above using dehumidification fans, the contractor and the owner never initiated formal testing of the area to determine if the area was indeed dry, and to confirm that there was actually no mold present in the interior ceiling cavity or on the surfaces involved. I had VM3 Environmental return again on June 13th to initiate testing of the interior ceiling cavity. The tests were sent to the LA testing laboratory, and the laboratory determined that 2 harmful levels of mold are present within the interior cavity of the living room ceiling as a result of the leak from Unit 12's faulty kitchen appliances, despite the efforts of the contractor initiated to dry out the area. Those 2 harmful levels of mold are Aspergillus and Clodosporium. I know you don't have the charts there, and I know this isn't the hearing, but I'm just trying to back up what I'm saying. I had given all the reports to the hearing officer, and every part of the evidence of those reports is extremely clear. There's not one lacking piece of evidence in those findings. It's very important to note that my ceiling throughout my unit was in perfect condition before I was displaced in October of 2018 due to the main water line erupting in the kitchen and dining room area. I have never had any prior water intrusion to this level that occurred in May 2019 from Unit 12. I was told by the contractor and the owner's son, Ryan Sasunian, that my unit would be restored and returned to me to its prior condition after I was displaced in October of 2018. They have refused outright to act in good faith to restore my ceiling to its prior condition, clear of all interior health hazardous mold. They also did not initiate testing on their own before declaring to building and safety and code enforcement that my unit was safe to move back in the first week of June 2019. This is why I'm appealing the decision to the hearing officer that made the decision for no rent decrease regarding the current living condition of the living room interior cavity of the ceiling. And I understand that code enforcement is very fixated on whether mold is visually present. However, there is positive mold in the interior ceiling cavity, and I know that cannot be seen by people's eyes, but it was fully tested and fully discovered and fully confirmed by a California state certified lab. I know the hearing officer and Lima had requested for me to have my representative present from BM3 Environmental during the hearing. However, I suffered a very significant, not planned change in my employment in November and a major financial setback, and I had already paid for a witness from BM3 to attest and, how would you say it, to testify in my honor or in my defense at a appeal hearing with Building and Safety for habitability back in September 24th, 2019.
Okay, thank you, Ms. Rostoker. If there are no commission questions from, sure, Commissioner Foster.
I don't have a question. I was just going to say, because we had some moments of technical difficulty, I didn't know if the tenant wanted to finish her thoughts briefly.
Yep.
Or
Ms. Rostoker, would you like to wrap it up in 1 or 2 sentences?
Hello?
Hi, Ms. Rostoker.
Okay.
Yep. You
Hi,
can
sorry,
wrap it up.
somehow it lost connectivity. I just was trying to say that I had paid for an expert witness from BM3 Environmental to testify on my behalf in safety hearing, which was at the end of September of 2019, in response to the habitability order that got redeclared on my unit after actually visible mold started showing. But then when code enforcement and one of the other people from Building and Safety came over here, they determined that it technically wasn't visible. I won't get started on how I feel about that. Anyway, I just wanted to make sure you guys were aware that I'm not the type of person that doesn't take accountability, and if I would have had the finances to have my witness appear again at this hearing, I definitely would have done that, but it was impossible because of this change of employment that I had no control over. In regards to, I just greatly appreciate everyone's understanding and justification for the request to re-review the circumstances and the certified evidence, which I know you don't have in front of you because it's not an actual hearing, but I had previously provided everything to the hearing officer and for the appeal. I turned some of it into Lima as well. And then as far as the video goes, 2 minutes, as far as the video goes of the window blinds that Amber submitted, that video shows that the turning mechanism, it doesn't show that the turning mechanism clicks when you turn it, and in her video, it did not show her opening the blinds one by one. It literally showed her sliding the whole group of blinds across and back. She did not individually open them on that video, and that is where the fault is in how it's operating now, and only a quarter of them open all the way, and 6 of them do not open at all. So that's my response about the blinds. And I understand about the pool pump. I'm going to be doing something else about that issue on the next time I get to actually file another issue with the Rent Control Board in regards to that. And I understand about the recycling, which continues to be a really conundrum, quite a big conundrum here at our building. We've had at least 5 times
Okay.
where the management did not take out the barrels. And that's it.
Thank you, Ms. Rostoker. We will be putting you back in the queue of attendees. Oh, do you have a particular question for? Oh, got it. Okay. Commissioner Foster has a question for Ms. Rostoker.
Okay. So I understand everything you've said, and just so you know, we do have we have everything that is part of the record.
Oh, great.
We have all of that. But I just wondered why, if you could account for the discrepancy between the page you submitted and the actual original page, because we're really bound by the law to go by the document that you submitted for the appeal. And as part of our packet, we have the exhibit. Can you explain that at all?
When you were talking about the pool pump, correct? Because that's the item that I had originally put on my petition.
The extra.
It was something that we even talked about during mediation with Bonnie, which I know I can't go into because this is a public meeting.
Yep. No, you definitely cannot.
I won't. But that item was specifically on that mediation, and it was my understanding that it also transferred to the paperwork that I turned in to rent control for the hearing as well. And I also just had thought that it would gotten transferred from the first part of the petition meeting.
Can I ask staff about that? Because I've never encountered that particular issue. Question for staff.
You mean?
The tenant is claiming that there was something that was part of our board's mediation that didn't get transferred. Is it up to the persons involved to fill out the form in its entirety?
Yes, there are a couple of issues. One, irrespective of what may or may not have happened in any mediation, the hearing happens based upon the application. So first the application's filed, and then there may or may not be a mediation, and then there's a hearing. So in this case, there was an application filed that didn't mention anything about the pool pump. And then there was a mediation at which that may or may not have been discussed, and then there was the hearing. The hearing, again, was on the application, not on whatever came up extraneously in the mediation. The other side has a constitutional right to know what issues are going to be before them, and we tell the parties as the part of beginning the process, here's the application that's filed, and here's what these are the issues that we're going to be deciding. So I'm not aware of people ever having brought up something new in a mediation and then later complaining, oh, why wasn't that forwarded or somehow communicated to the hearing officer? One, it would be illegal to talk about what was in the mediation to anyone else outside the mediation. So, and the parties are told that what happens in the mediation is confidential, so they have no reasonable expectation that anything's going to be forwarded on. But even beyond all of that, what happens in the mediation is not a decision-making process. The decision-making process is based on the application, and the application did not mention the pool pump.
Okay, that answers my question. Thank you.
Okay, if there are no other questions from Ms. Rostoker, I'm going to invite you back as an attendee, so you will no longer be able to communicate with the board. Thank you for your public comment.
Okay. And I'm not allowed to comment on what he just said. Is that correct?
That's correct. Let's see. Okay. And I just sent Ms. Rostoker over to be an attendee. Looks like she's now an attendee. I'll kick this off. My main concern about this is that, there is a document that does appear to show that there's unhealthy levels mold, and it was my understanding that the board does not strictly adhere to the rules of evidence. So while the hearing officer, may have some discretion to not give it a particular amount of weight, I think it's not proper to disregard it simply because the petitioner was not able to pay to have their expert witness, authenticate the report. Certainly if we were in a judicial proceeding, I think, that would be a little trickier. Counsel, can you please confirm what our governing standards are for receipt of evidence and how strictly we adhere to the rules?
Yes, there are really two parts to answer this question. One is the board can accept hearsay evidence. It's not barred from accepting it, nor is the hearing examiner. The board cannot make a decision based upon hearsay evidence, though, and that's a matter of state law.
Right.
Also, as to this particular evidence, the reason it wasn't that the hearing examiner said, well, you didn't expend the money on having a witness come to talk about this report. It's that one, it was hearsay. It couldn't be made non-hearsay by a witness testifying about it. But two, the hearing officer doesn't have the scientific or technical expertise to interpret the report, and the report does not say that there are dangerous levels of mold. It sets out what findings were about mold that was found. It doesn't say how it compares to the ambient mold. So there is no statement in that report saying, here's a kind of mold, this kind of mold is dangerous, this is a safe level, and it's beyond that safe level. So there were really two disabilities and two evidence issues. One is, can the hearing examiner consider hearsay evidence? Yes, they can. Can they rely upon it as a basis for decision? No, they can't. Moreover, can they act as their own expert? And no, they cannot do that because they don't have that expertise.
Right. So that's really helpful. It's hard, I think, when you have these proceedings and they're set up for people who it's not supposed to be required that you have to pay money for a lawyer, pay money for expert witnesses. I worry, about, from a policy level, just how difficult it might be for tenants who are living with mold to prove it and to get a decrease or create any incentive for the property owner to remedy it, because it sounds like absent non-hearsay evidence of a mold problem, it would be very difficult to prove. That said, I don't think it changes the outcome in this case. I think we're obviously bound by a very high standard on appeal, but I'm worried about accessibility of relief and ways that we might be able to address that. Looks like we have Commissioner Duran is next in the queue. Commissioner Duran.
Thank you. I do feel for the tenant. I feel because I sense and I totally understand that there may be this feeling of helplessness with the mold issue. What do you do? It's not something you can necessarily just, wipe away and it's gone forever. If there's, there can be a whole bunch of other issues that don't let it go away just by self-help. And so I understand that helplessness issue. But one of the things I also understand is that when you bring somebody to talk, the other side needs to have the opportunity to cross-examine. And though these reports were here, as counsel stated, there was nothing that directly said, the levels were X and it surpassed a safe level and therefore it's unsafe for the tenant. Absent an expert, I think we really I think it's pretty clear in this case the way we have to rule. But the question I have for council is, if this mold issue remains an issue, can the tenant bring this claim again? And if so, when? Or is there a time period, or is there a res judicata effect, or what? Explain that, Mr. Lewis.
Well, there's no res judicata effect because the only recommended finding here is that the tenant didn't prove the condition that she was claiming. Not that the condition, there was no finding that the condition does not exist. Second, the tenant has, I believe, 180 days to wait before they can file a new application, which period the board can, if it wishes, waive. Also, just to this may be relevant for the parties as well as the board. The problem in this case is the means by which the tenant thought to prove the problem, which was, here's an expert's report, and it's just a piece of paper, and there's nobody to talk about it, and the report itself doesn't say what she's hoping that it will say. The board has, and hearing examiners have, given rent decreases on the basis of mold, based upon evidence that wasn't just hearsay evidence, that wasn't explained, or scientific evidence that there was no foundation for. So parties can and have proved the existence of mold and have gotten decreases for that. But in this case, it's really just a question of the condition not having been proved, because the mode of attempting to prove it was simply a piece of paper from a report that doesn't reach any specified conclusion, and nobody there to talk about what the technical things in the report might lead an expert to conclude. So there is a time limit of, I believe, 180 days, and the board can waive that if the tenant wants to refile sooner.
And I have one other follow-up question. I guess something that I just want to say as a general comment. What we're deciding here today is whether, as a result of the mold issue, if we decide to go one way or another, what we're deciding is that a rent decrease is appropriate. It's not that we can force or get the mold taken away or fixed or repaired. That's an issue that the tenant's still going to have to figure out, on her own or with the help or assistance of the landlord. So anyway, I just wanted to put that out there, and also reiterate the fact that I do think that the landlord should have the opportunity to see the report, but also cross-examine on the results of it, and there should be an expert. So I would say the way I'm feeling on this is to affirm the hearing officer's decision based on the evidence that was presented, because I don't see that anything is clearly erroneous, but at the same time waive the 180 day waiting period for her to bring back another petition. If the mold issue is really an issue, she can get all her ducks lined up, get everything she needs to, just to see about getting a rent decrease or find some other remedy.
I think that's I like your plan, Commissioner Duran. I think that's right. Our next speaker in the queue is Commissioner Terosis. Oh, you're on mute. Unmute.
Sorry, I just wanted to say that I will second that motion. He laid out the reasoning that I would agree with, and I'll second the motion.
Commissioners, if I may interrupt for a clarification, are you waiving that 180 period generally, or for specifically for the mold issue? That is the motion.
I'd be inclined to waive it generally because of it looks like her apparent confusion about the mediation. I realize it's difficult to do these things when you're self-represented. You don't have kind of a lawyer or an ombudsman to kind of help you navigate the process. So I would be inclined to have it be a full waiver of the 180 days, but I'm hoping to hear from my fellow commissioners.
I would
That's what
agree
I
with
thought
that.
too. So I seconded, so let's take a vote unless other people want to comment.
Great. Let's call that vote. Can we have a roll call vote, please?
Commissioner Sultan? Commissioner Foster?
Yes, I did not hear Commissioner Sultan's vote.
Commissioner Sultan?
Was on mute, but that was a mute yes.
Commissioner Duran?
Yes.
Commissioner Terosis?
Yes.
And Commissioner Phyllis?
Yes.
Motion carries.
Okay. And could we direct staff just to make sure that they connect with the appellant and petitioner, just to help make sure that she has an understanding of the process? I'm sure we've done this before. I just want to make sure, because it does look like she was confused, that we make a point to try to connect with her and make sure that she understands what the ruling of the board was and kind of what her options are. Okay. All right. Next. Okay. Next item on the agenda, we will be returning to the appeal of 1321 Harvard Street. We've already had a staff report. So we are going to give this a second try with Mr. Chekaloff, who is the appellant and has requested 5 minutes to speak. Mr. Chekaloff, we're going to elevate you. It's going to take about 30 seconds and unmute you. Let's see if we can get this rolling.
So while we're waiting for him, commissioners, I did talk to them on the phone, and they're hoping they figured out what the problem was. So we'll see what happens. We have a backup plan if it doesn't.
I love backup plans. That's great. Okay. Mr. Chekaloff, looks like you're here and unmuted. Testing Mr. Chekaloff. Okay, Mr. Chekaloff, we cannot hear you. Mr. Gwynn, do you want to enlighten us with the potential backup plan?
Yeah, what I think we can try to do is I'm going to call him on the phone, and then I'm going to hold his phone up to my audio.
Okay.
And we'll see if that'll work. So I'm going to call him on the phone. So if you want to demote him, because we don't want him to, there could be a lot of feedback if we have a lot of things going. So we probably want to demote him down back to a attendee. And then I will call him just a second.
Great.
Ready to start?
All right, just a second. All right, I'm going to have them speak, commissioners, and we'll just see how this goes in a second. So go ahead and speak, Mr. Chekaloff, and just do a test.
Can you?
Unintelligible.
Okay.
Oh, better.
I'm Mr. Chekalov, and okay, yeah, just thanks for Miss Oscar. Trying to organize everything here. There seems to be a discrepancy in a lot of things as far as what the definition of, for instance, tenant non-occupancy is. You know, let's see here. I'm trying to get a little bit nervous and out of my element. But here we go. Okay, so it says per rent control guidelines, it says once a prima facie case has been established by the petitioner, the burden of proof falls upon the tenants. However, it seems as though in practically every instance with those rules, because everything the tenants say seem to be as taken as fact, and everything we, being the petitioners, say treated as I don't really want to say a lie, but something that we have to inadmissible, and you know, I just want to point out that you know, the pattern continues. We haven't seen tenants March 12th, date of the last scheduled hearing, because they don't live here. And, you know, as on-site managers of a family-owned and operated business, my wife and I observe and know all of our neighbors' living habits. Their routines are extremely predictable, which makes any changes in their routine. These changes are not only obvious, but they're all documented by 8 high-definition surveillance cameras we have all around, and you know, yeah, which not only create a record but allow for any question be monitored and reviewed. Several months ago, we added we added a 3 terabyte external hard drive to have every second of the record of activity around our property backed up. You know, I heard what on your last case, or no, excuse me, I heard one of the commissioners there state that we just had some, when he was reviewing our case before I had a chance to speak, he stated that we had some snapshots, because watching a security camera for I don't know how long,
24 hours a day.
24 hours a day would be boring. It's no movement. We have one trained directly on their front door, and like I said, they don't live there. But, you know, right now someone else is living there, and I mean, we know what's going on, and it's just, I mean, Michael Shundoff himself admitted that he was not there for the month of October last year. Or was it August? August. That constitutes, in my opinion, a tenant not an occupancy. They haven't been there for a month. I don't know what else to say. There's a discrepancy in what we, you know, what the definition of living somewhere is. They claim they live there, but they're never here. As far as the you know, the witnesses, we went so far out of our way to get those witnesses here. They are right closer to them than we are. They both noticed the change in the fact that they were never there. following that particular date. I don't know, it was last May, or I don't have it in front of me, but it's, I don't want to get involved in other people's feuds. You know, they make it extremely hard to be subpoenaed. We went way out of our way and wanted to cooperate.
Okay, looks like we have lost Mr. Chekaloff. Mr. Gwynn, do you have any insight into
Or maybe that was.
maybe it was time? I'm not sure. Okay, it appears that both Mr. Gwynn and Mr. Chekaloff may be having technical difficulties. As a board member, you know, I feel like the packet was comprehensive. We have heard a lot from Mr. Chekaloff. I realize that some of his presentation may have been limited by the technical difficulties, but I do not think that that in any way impairs our ability to have a full and fair deliberation. Mr. Lewis, is there any reason why we cannot proceed with the remainder of the speakers?
No, the evidence has all been presented. There's nothing that was said in Mr. Chekaloff's oral presentation that isn't what he's already said in his written presentation. So no, I see no reason why the board cannot proceed.
Okay. We will be proceeding then with the remainder of our speakers for this evening. It looks like the next speaker was Ms. Kaylee Chekaloff, although I do believe I did hear her in the background, which means that we will, if there's no one else on the appellant side, we'll be moving to the appellees, starting with Ms. Harper. Ms. Harper, I'm going to elevate you into the queue, and we will have about a 30-second delay, and then, yep, it looks like that's it. Okay, so Ms. Harper, just bear with us for a few minutes. Okay, Ms. Harper, I'm going to unmute you in about 10 seconds, and you will have 5 minutes for your oral presentation. Okay, Ms. Harper, your 5 minutes starts now.
Hello, this is Mike Shundoff. Can you hear me?
Hi, yes, Mr. Shundoff. Will you be speaking on behalf of the appellees?
Yes.
Great. So you have 5 minutes.
Okay, great. Thank you. Ladies and gentlemen of the board, with regards to the facts in this case, we feel that we have more than sufficiently met the burden of proof that the unit is our residence of usual return. This has clearly been outlined in the staff recommendation as well. The Chekaloff's behavior during these proceedings has been downright despicable. They initially showed no interest in resolving this case amicably, as they never even asked for an explanation for their accusations and instead went straight to filing for a ruling of tenant not in occupancy. They then proceeded to harass both us and our roommate, while they knew perfectly well that we had every right to have roommates. This harassment eventually led to the point that our roommates could no longer bear it and have moved out. The so-called evidence that they submitted that was not permitted by the hearing officer was their financial statement, saying that they don't make enough money off of the apartment building. Make no mistake, that's exactly what this is, a money grab. Chekaloffs have demonstrated that they have no regard as to the veracity of their claims and are content to force us out of our rightful home, if at all possible, so that they can make more money. Kevin Chekaloff, when confronted, even stated as much, telling us that it's just business. This business practice is downright deceitful, and this body is our only line of defense as tenants against landlords that seek to threaten the livelihoods of their tenants for the sole purpose of making an extra dollar. We're also not we're also not only the only rightful tenants that the Chekaloffs have attempted to extort in this fashion, as another petition that was filed for tenant non-occupancy was recently decided in favor of our neighbors in apartment 1.
One, it's important to confine any testimony to this case, and
Okay.
two, the board should disregard any characterizations of what a party did as harassment or what their motives were, because the question is only what is the domicile of the tenants, not what are the motives or attitudes of the parties.
Okay. So in that case, then we respectfully request that the facts presented in the case continue to serve as the means by which it's decided, and that the original decision be upheld. And we're happy to answer any questions you have, and thank you for your time.
Thank you very much, Mr. Shundoff and Ms. Harper. I don't see any questions from my fellow commissioners. You know, before we move into deliberation, I want to say that I am horrified to hear that there are apartments that have cameras pointed into them. I think that that's deeply disturbing. Sorry, this is not supposed to be an interactive part of the evening. I will, that was a good reminder that I need to move you back into the attendee presentation. But having heard, this is not before us specifically tonight, but I am deeply concerned about what appears to be going on in this building, and persuaded by the staff report and the testimony that I've heard that we should affirm the hearing officer's decision.
Commissioners?
Okay.
Commissioner Phyllis?
Yes.
Can you hear me now? This is Lonnie.
Yes, we can.
Okay.
Welcome back.
I had to reboot. I had the other party on the phone again when this happened, and they're still requesting that Mrs. Rosslicker would like to speak for a moment. I don't know whether you want to try to do it as we did before and have her just speak for a little bit, or what you want to do. They're obviously listening, but I'll have to call them back.
So Mr. Gwynn, I think you mean Miss Chekaloff, not Miss Rosslicker.
Chekaloff. Oh yeah, I'm sorry. Yes, Miss Chekaloff. Yes.
Okay. They can hear, I think, where the board is going, but I would be inclined to hear from everyone. I don't think we want to hold technical difficulties against anyone. Is there a consensus from the board that we give? Great. Okay, so why don't we give Ms. Chekaloff about 3 minutes?
Okay.
The appellant already had 5.
All right, I'm going to have him get on the phone here just a second.
Great.
Hi, Ms. Chekaloff? Yeah, I heard you already heard them. I'm going to put you on speaker again, and they're going to give you 3 minutes to speak. Just a moment. Okay. You can go ahead.
Okay. Yeah. Okay, great. Thank you.
Okay. We can hear you now. Yep.
You can go ahead, Ms. Chekaloff.
Okay. Ready?
Go ahead.
Yep.
Okay. Can you hear me?
Yes.
Yep.
Okay.
Your 3 minutes is started. Yep.
Okay, so, yeah, I wanted to state that, okay, great. I wanted to state that, this claim of harassment is, it's absurd. The reason why we put this other camera up, which is not trained into their apartment, I might add, just trained in a tree high up, just facing back building, and it could see who comes in and out of their apartment, as well as who comes up and down the pathway. It's for security as well as to prove our case, because after the results of everything, seeing that all of our evidence and everything is considered, I don't know, just circumstantial at best, we had to find another way to prove our case. I'm not really sure how at this point,
we're expected to prove a tenant's non-occupancy when we tried so many times to ask the hearing officer what exactly tenant non-occupancy even means. It makes it very difficult to prove something. We were under the impression that it meant that basically if they are mainly somewhere else at another property, that would prove that they are tenants non-occupancy, or that is that their primary residence is not Unit 6 of 1321 Harvard Street. But I don't know, I'm not secure anymore at this point. I just wanted to point out that there was another, I amended my response, my original appeal to the first staff report, and submitted that, and that they said that it would be considered, but I'm unsure of whether it has been. It says for board supplemental staff report on appeal, and it was just 2 pages. Yeah, we just got it 2 hours ago. I didn't even know
that was 3 minutes.
Received a response. But yeah, basically, I guess I'm going over my time.
Yeah.
But it kind of made it difficult to prepare further when we just received this document. But from Lyman Notes.
Okay.
All right. Well, thank you, Ms. Tricloff.
All right. So we're going. That'll be it, Mr. Chekaloff. They're going to now debate further.
Yeah. Hello?
Yeah. They're now
I'm
going to debate some more.
Yep. I'm gonna mute Mr. Gwynn for the time being. Oh, is that okay? Yep. Yeah, I think that's the right thing to do. It looked like there may have been a question, possibly for Ms. Chekaloff. I wasn't sure. Ms. Sultan, did you have a question?
Yeah, sure. My question is Ms. Chekaloff still there?
It's almost impossible for you to hear. I'm sorry, Ms. Sultan, because there's going to be so much. Yeah, it's going to be so much echoing if we do that.
It's okay. It's okay.
Okay. Yep.
Commissioners?
So, yes.
I just wanted to clarify that Ms. Chekaloff was referring to her response to the staff report, which you did receive, in addition to the supplemental staff report in your packet.
Yeah, I understood that.
Thank you, Mr. Mordside. Okay. I believe so we have a queue of commissioners who are eager to speak on this. Looks like the first speaker, Commissioner Sultan, did you also want to kick off deliberation? You were first in the queue, but I wasn't sure if that was just limited to a question. You're on mute.
Yeah, no.
Okay.
Oh, okay. I'm with you guys here. Yeah, I'm also inclined to affirm the recommendation of staff. I did want to, because I'm not hearing anything about, from the appellants about that would suggest that the tenants aren't in residence. Being gone for a month, that's not dispositive. It's about being your usual place of return, and I believe that there's significant evidence to that. But I wanted to echo what you said before about the cameras, because I find that admission by the landlords here extremely disturbing. That there's 8 cameras operating full time on the property, and 1 is trained at the door of these particular tenants, so they can see everybody who goes in and out. I just find that, very distressing. I certainly wouldn't countenance it in my own apartment building. And I think people need to worry about violating the privacy rights of their tenants. Tenants, do have privacy rights. And I'm very concerned about that.
Right, to interrupt while I'm not making any comments on the validity of the concern or the importance of those issues, but in order to have a clean record in case there is an appeal, it's very important that every deliberation be limited to what is necessary to decide the case so that there's no appearance that the board decided reached its decision based upon anything other than those things affecting the actual issue before.
Sure. Yeah, no, I mean, that concern is independent of the fact that I don't see any evidence here that their tenants are not in evidence. And that is something that they themselves brought up. So that's why I wanted to just respond to that. But that's absolutely, a separate concern from this particular petition.
Right. Yeah, and I will be brief, but I think tenant harassment at any time is morally repugnant, but tenant harassment, particularly during the time of a public health crisis, is nothing short of grotesque. And that's why our city has increased civil penalties to $15,000 for tenant harassment violations. And I certainly hope that if tenants feel harassed, that they will avail themselves of the resources of the city attorney's office, because everyone deserves a right to shelter in place in peace during this public health crisis. Looks like the next person in the queue is Commissioner Trosis.
Thank you very much, Chair Phyllis. For me, having read the entire record that was provided, as well as the response in the supplemental staff report, I think, we've had several of these cases regarding tenants not in occupancy. I think I'm pretty familiar as to what the legal standard is and what the law is. I think we have to look at where the tenants are actually domiciled. And I think in this case, the showing of the driver's license, the voter registration, the utility bills, and for me, what I think very relevant, a certified sworn under penalty of perjury loan application stating the address in Santa Monica as their primary address. And then additionally, even on top of that, these firsthand witnesses who testified to them living there, I just absolutely don't see how anyone could reach a different conclusion other than this is their domicile. And to me, again, not relevant whether they're taking vacations or going to their vacation home. Again, this is where they live and work and make their money. So with that being said, I'm ready to affirm the recommendation and uphold the hearing officer's decision, finding of facts and conclusions of law. And I can make a motion to that point, or did we already?
No motions have been entertained yet. We did have Commissioner Duran, I believe, who wished to weigh in the queue, but he looks like he's shaking his head and he looks like he has heard enough. So there's a motion. Is there a second?
I'll second Commissioner Duran.
So Commissioner Trosis moved to adopt the findings of fact and conclusions of law to find that, to affirm the hearing officer's decision. There's a second by Commissioner Duran. Can we have a roll call vote, please?
Yes, Commissioner Foster,
Yes.
Commissioner Sultan,
Yes.
Commissioner Duran,
Yes.
Commissioner Trosis,
Yes.
and Commissioner Phillips.
Yes.
Motion carries.
Okay. Our next item on the agenda is administrative item 12A, which is proposed new regulation 15020, respecting the temporary suspension or alteration of regulations governing administrative decision processes and procedures during this public health crisis. May we have a brief report, please?
Yes. Just before the board's March meeting, the city declared an end to all public meetings, and shortly thereafter, there was a declaration of state and local emergency in response to the COVID-19 crisis. When that happened, the board was not going to be meeting again until its April meeting, but there were a number of things that had to be done in order to secure the safety of the board staff as well as the public. And one of those actions was to, in conformity with the social distancing requirements, to suspend all in-person meetings. The board's website currently says that hearings which is a big part of what the board does, are suspended until April the 30th, until the end of this month. When that was done, it had to be done without the board taking action, and that was simply a matter of practicality because the board was not going to be meeting, and we couldn't have these hearings taking place and people proceeding with things that might put them and the staff in danger. We also, though, immediately tried to figure out how we could resume the board's primary functions, including the holding of hearings, as quickly as possible, and are now preparing to do that at the end of April. This crisis made clear that there are times when an emergency occurs without any warning, as would happen in the case of an earthquake, or as happened in this case, not that there was no warning, but it happened very quickly, that it will often be the case that decisions have to be made respecting not fundamental rights or what the law means or how the law works ultimately, but respecting processes and procedures that the board is not in a position to make, either because it's not going to be able to meet quickly enough or because it's not able to meet at all until a time after those decisions would have to have been made. And we also have realized from this emergency that there are not only emergencies that arise suddenly, but also that there are emergencies that evolve. One possible approach would be to enact a set of regulations that apply to whatever emergency happens to be in front of us. And one hopes that that wouldn't result in us becoming cluttered with regulations, because one hopes that we wouldn't have so many emergencies. But it is the case that we can't anticipate in advance what our needs will be or what those emergencies will entail. For that reason, I've proposed to the board that the board give to the administrator a limited amount of authority to take those actions and make those decisions necessary to suspend or amend procedures or processes only to the extent that is necessary to accommodate the emergency that's occurring at the time, and only until the board itself has an opportunity to either ratify those decisions or to reject or modify them, and only for the duration of the emergency. If the board wants things to continue as they were during the emergency with respect to processes and procedures, it would have to either enact regulations in the ordinary course after the emergency was over, or before the emergency was over, modify the emergency conditions that were put in place by the administrator as ratified by the board to continue to a date specified, supported by findings that support, one, continuing them, and two, continuing to that date certain. For that reason, I put before the board a set of, as you'll see, very basic regulations that do no more than give the administrator the authority to make those decisions, as I said, concerning processes and procedures only, not concerning anybody's rights, not concerning the ultimate effect of the rent control law, and only until the board itself has the opportunity to weigh in on them, and only for the duration of any emergency. I've included the regulations themselves as an appendage to the staff report. Thank you very much.
Thank you. Our first speaker in the queue is Commissioner Foster.
Thank you, Chair. Everything made perfect sense. And, we hope we don't have these kinds of emergencies going forward, and we hope this one doesn't last too much longer. But in light of everything that's happened and the way it's been handled by staff so far, I am supremely confident in the ability of Ms. Condon to make those calls. And I think we have a long body of history showing us that staff will always eventually bring things to us in a timely fashion so that we may ratify or modify as the case may be. So I would be inclined to accept this staff recommendation.
Great. Looks like Commissioner Torosis.
I was going to second.
Okay, we have a second from Commissioner Torosis. I also see that Commissioner Duran has requested to speak. Commissioner Duran, would you like to speak on the motion?
Well, Yeah, I would like to speak. I understand that there's been a first and a second. Maybe it goes along. If you'll allow me this minute, I think I'll be brief, and I think it goes the way everybody else is going. What I like about the way it is drafted is I agree with Commissioner Foster that I have 100% confidence in the current staff that we have here handling the situation properly, efficiently, quickly, and which is fantastic. We're lucky to have them. But what I like about what's written is that, at some point in time, somewhere down the future, we're not going to have necessarily this fabulous staff, and it's written in a way, I think, that keeps the control and keeps it specifically defines, when the emergency may start and when it's going to end, and that they have to continue reporting to the board to make sure everything is going along smoothly. And so, for that reason, I just wanted to add those comments. That I think it was well written, and it states specifically what needs to be said, and gives good guidelines about the parameters. That's it. Thank you.
Thanks, Commissioner Duran. So we have an outstanding motion and a second. If no one else would like to speak, seeing no one in the queue, can we have a roll call vote, please?
Yes, Commissioner Duran,
Yes.
Commissioner Foster,
Yes.
Commissioner Trosis,
Yes.
Commissioner Sultan,
Yes.
and Commissioner Phyllis.
Yes.
Motion carries.
Thank you. Okay, so that brings us to adjournment. Is there a motion to adjourn?
Move to adjourn.
Second.
Okay. There's a motion and a second. We need a roll call vote to adjourn? I think we do. Okay, Mr. Gwynn, can you call the roll for adjournment?
Commissioner Duran,
Yes.
Commissioner Trosis,
Yes.
Commissioner Sultan,
Yes.
Commissioner Foster,
Yes. Good night.
and Commissioner Phyllis.
Yeah.
Motion carries.
Hey, congratulations. Our second online interactive board meeting has come to a close. Looking forward to seeing everyone next month, and hope everyone stays safe.
Can you remind us of the date of the next meeting?
Yes.
Yes, actually, we're going to have two meetings in May. We're going to have one on May 14th and then also May 21st. And the 21st will be the presentation of the budget, the proposed budget for next fiscal year. So the next meeting's May 14th, and most likely also by video conference. We'll see.
Okay.
Okay?
Thank you. Thank you.
Public health first. Stay strong. Flatten the curve.
Thank you.
Okay, bye.
Bye-bye.
Bye.